for the welcome to Ngunnawal country. I also want to acknowledge Aboriginal and Torres Strait Islander peoples as the traditional custodians of the land, acknowledge all of our elders, past, present and emerging, and acknowledge the continuing care of country, culture and communities by our people. I acknowledge the Indra people of the Ngunnawal Nation where I live and work and come from you here today. My name is Sharynne Hamilton. I'm a proud Aboriginal woman. I'm a mum and an auntie, and my family connections are to Ngunnawal country in Canberra and Yass. As a baby, I was removed from my family by New South Wales Docs and placed in an institution, and then grew up in the foster care system before being adopted as an older child. Grew up without any knowledge of and completely disconnected from my family and my culture and community. Connected very briefly with my mum and some of my siblings in my early 30s, which was a really difficult experience. There was a lot of trauma and a lot of grief and loss in my family, which proved insurmountable at the time. Unfortunately, my mum passed away before I saw her again, and much later in my 40s, I returned to Canberra and I was able to learn more about and connect to my family and community. And it was then and really only then that I could really begin to piece together my identity and who I was and where I belong. So it's this lived experience and many years of professional and research experience across my life that informs this keynote address. So as you've seen in after the apology, the impact of the stolen generations and many other policies which saw the disruption of our culture and the way of life of our peoples has been devastating. A few Aboriginal and Torres Strait Islander families in this country that have not in one way or another been impacted by the stolen generations policies. And the legacy of across our communities has been and continues to be shattering. We need recovery pathways for our future generations to thrive and to grow, to be strong in kin and culture and language and with connection to and knowledge about their country. So just a bit of background, there are currently over 23,000 Aboriginal and Torres Strait Islander children in out-of-home care, 10 times the rate of their non-Indigenous peers. Most recent Snake Family Matters report tells us that this overrepresentation has increased at a higher rate than the overrepresentation of cases of substantiated child abuse or neglect. Our babies under 12 months are being removed at 10 times the rate of non-Indigenous children. The risk of removal is increased for our women who are incarcerated. Reports findings show not only are more of our children being removed, but they're spending longer time in care on permanent orders. They're being adopted at very high rates by non-Aboriginal families. Reunification rates are low. Thousands of our children are in long-term care arrangements with no identified family reunification goals. The findings also show that where our children were reunified, more than 84% were successful. These children did not return to care in the first 12 months after returning to their families. When in out-of-home care, our children are equally likely to experience neglect and more likely than their non-Aboriginal peers to suffer physical, sexual or emotional abuse in care. So the very system set up to provide care and protection then perpetrates abuse. It's totally unacceptable, but it's not new. More than 60 inquiries into the operations of child protection services in 50 years have reported the abuse of and poor outcomes for children in state care, and they've had little to no impact. The Bringing Them Home report's our story, and little has changed 25 years on. 32 years on from the Royal Commission into deaths in custody of our people. That's our story, and again, little has changed. There's a lack of progress in closing the gap targets to eliminate the overrepresentation of people, Aboriginal people involved with the criminal justice system. Nationally, our kids represent over 50% of the youth detention population, 21 times more likely than their non-Aboriginal peers to be incarcerated. And then around 50% of these kids are also involved with or under the care of the child protection services. So with this information in mind, and to give you some context on what I'll talk about in terms of critical areas of capital, I'll talk briefly about a study at Banksia Hill Detention Centre in Perth This research was conducted to explore the potential prevalence of fetal alcohol spectrum disorder, or FASD, in the youth detention population in WA. Average 75% of kids out of Banksia are Aboriginal. They're as young as 10, and many are brought to detention from very remote and regional areas in WA, up to 3,000 kilometres. In the study, there were 99 kids assessed. 75% of the kids were Aboriginal. They underwent multidisciplinary clinical assessments, health, neuropsychological, speech and language, and motor skill assessments. 36% were diagnosed with FASD, and a whopping 89% had at least one severe neurodevelopmental impairment. So what does it mean to live with neurodevelopmental challenges? For these kids, the highest levels of impairment were found in academic functioning, low literacy skills, low school attendance, poor academic achievement, early disengagement from school, expulsions, suspensions. Many of these kids had impairments in executive functioning, the part of the brain that controls memory and the ability to focus and pay attention, to control impulse, to plan, to solve problems. Many also had language and communication difficulties. For many of these kids, there were additional comorbidities like alcohol and other drug use, mental health problems, health conditions, and conduct disorders like ADHD. Their neurodevelopmental challenges negatively affected their social skills and their relationships. So I was a qualitative researcher on the study, and the research interviews that I undertook included young people in Banksia, their parents and their family members, their professional networks in the community, and non-custodial rehabilitation staff in Banksia. I talked with the kids about their lives and their families and communities, their hopes and their goals, as well as seeking to understand their experience of undergoing assessments. What was very clear was that they did not understand a lot of what the assessments were about or what having a diagnosis meant. They really required significant explanations in a range of ways, but particularly using visual aids and drawings in order to provide explanations and manage confusion and facilitate relationships, and to ensure that we mitigated stigma, the potential for stigma and harm from receiving a diagnosis or diagnostic information. Especially for FASD, it's a very stigmatising diagnosis. Similarly, with their family members, there were very, very different cultural understandings of disability and what that meant for our children. In terms of their lives, a quarter of the kids I spoke to were in the care of the State Child Protection Service prior to being detained in Banksia. These are some of the quotes about their child protection experience. The stability was a major problem, disconnection from family and community. One little fella telling me, "Miss, I just grew myself up." He'd been pretty well on the streets, and Banksia was a revolving door. His goal in life was to be in the big house, adult prison across the road with his uncle and brothers. It was very sad. Hearing these stories about their foster care experiences were heartbreaking. I was hearing my own story being told to me by our kids more than 50 years later. The stories, often spoke to very complex family circumstances, very often saturated by the transfer of intergenerational trauma from forces of colonisation. It's well established that trauma, particularly repeated and complex trauma, also significantly affects neurodevelopment. Great concern, despite their involvement with multiple services like the police, the justice system, community organisations, schools, child protection services, the young people's neurodevelopmental challenges were largely unrecognised, were undiagnosed, and so it was never considered in professional responses to their needs or to the provision of services for these kids. And so this research really raised for me much broader concern about how the kids and their families were able to navigate and get their needs met within a complex legal system, particularly, when professionals are blind to their disability, they're operating in the dark. And the results really provided us with an opportunity to apply a different lens to what we expect and how we understand and care for our children and their families involved with these systems. How can we assist to develop recovery pathways and opportunities for healing? So I explored this work through a lens of recovery capital, Recovery Capital provides a tool for collecting information which can assist individuals to connect and grow. It's a strengths-based model, and it considers positive and negative influences on individuals' recovery pathways. So considering negative influences in family or social networks, as well as looking at who the positive peers are, who are the important people in this child's life and the mentors in their life. Looking at what resources and what opportunities or pathways there are to follow personal goals. So things like whether there's unsafe or safe housing, whether there are pathways or no pathways to education or employment opportunities, what access or barriers there are to participating in recreational or pro-social activity. Can collect a lot of information that can be brought together, to support finding positive recovery pathways for our kids. However, the model didn't account for the challenges that these kids can experience by having neurodevelopmental disability, and nor did it account for cultural needs that are very specific to, cold or Indigenous populations. So I worked with UK Recovery Capital expert, Professor David Best, to explore the potential for the addition of justice capital to the recovery capital model. Because if we can think about neurodevelopmental and cultural resources that allow or prevent individuals from navigating and understanding and communicating and being engaged fairly in all their systems of care, service provision, then chances are we'll see better outcomes. If these things aren't considered, then moving away from disadvantage and towards recovery will be very, very, very challenging for these kids. The personal justice capital is about having an individual's access to the resources they need to participate in their systems of care fairly and equitably. For our families, this means thinking about access to culturally secure and relevant systems of care and support, and about the forums that provide a place that enables voice and participation when decisions that affect our lives are being made. The concept of justice capital is particularly relevant where decisions that are made about when decisions are made about a person that limits their rights or liberties. So the criminal justice system and its prisons and youth detention facilities, the child protection system where the state intervenes in private life of family and just takes children away, immigration detention centres where it's not unheard of for people, including children, to languish for years. The stakes can be very, very high when we get things wrong, and decisions that are made often have lifelong and harmful consequences. It's also highly relevant to many situations experienced within the broader Australian community where there's need. The COVID-19 virus and the dissemination of health information about the virus and vaccinations. Fires and floods where people need to have access and support and advocacy in many areas, from filling their basic and immediate needs to understanding complicated and insurance documents and the like. We've seen very complex problems with participation and access to the National Disability Insurance Scheme. People struggle daily with our Centrelink requirements, with understanding housing obligations, tenancy agreements, tenancy rights. So in the development of this work, I started thinking very much about not only how personal justice capital assets and needs can be collected and utilised for benefit, but how is it that the systems the kids were involved with, the child protection system, the justice system, and the broader systems of care, how do they support these needs? What are the aspects of an environment like a prison or another institution that creates the conditions for fair and equitable exchanges to happen? We explored this in the context of UK prisons and argued that at an institutional level, justice capital is the extent of belief in reintegration and rehabilitation for all, and the embodiment of that belief in the activities and the relationships that actively promote positive change. Where personal justice capital and the institutional component come together, it's in how we trust, how we share these beliefs and how we share ideas about what can be done and what should be done. And, then and really only then is there really a possibility for sustainable change, when we all agree. We've also begun exploring ideas of personal and institutional justice capital in child protection work. Between 2011 and 2015, I undertook an internship at ANU, and I was very fortunate to work with Professor Valerie Braithwaite and the Community Capacity in Child Protection Project team at RegNet there. Part of the project, we conducted a study in Canberra to explore how community organisation workers from a wide range of services were able to advocate for and support families involved with the Child Protection Agency, in addition to the support roles that they already provided to clients. So it's been very well established that parents and family members are highly stigmatised, involved with the child protection system, are highly stigmatised and a marginalised group in society. During the interviews, we were hearing stories from workers that very much reflect the same stories that families told. So to understand more about whether community workers experience stigma in the same or similar ways as families, or what is termed courtesy stigma or stigma by association, we looked at the data first to explore whether or not community workers felt parents and family members were a stigmatised group, and we found very clear evidence that they did. And from there, we looked for indicators of courtesy stigma, specifically descriptions of negative stereotyping, professional denigration, being undermined in your role, and we looked for examples of exclusion. We asked whether community workers perceived that child protection workers used what they had to offer about their work with families. They feel valued in their role. Community workers were very critical of child protection workers for not looking at them as partners, for not valuing their expertise, and they didn't feel trusted, and they didn't feel that they had an effective voice for families that they worked with. So I worked with my colleague, Dr. Sarah Maslin from the University of Canberra, and we revisited all the interviews. One clear finding in the data was that there were very different perceptions of risks between community organisations and child protection workers. In the interviews, we heard stories where the removal of children didn't occur when community workers felt it was in their best interests. And we heard stories where the removal of children shocked community workers. They rocked entire organisations. There was little confidence in risk assessments. They were considered to be very subjective and very ill-considered. Sarah and I also looked for evidence where community workers identified aspects of personal justice capital and how this intersected with the advocacy and support undertaken by the community workers. So this first quote's a really good example of personal justice capital need. No information of the process and what's going to happen, agreeing with and signing documents that they don't understand. They have access to the resources and support that support equitable participation and personal growth. Really not yet. There's so much at stake for these families. And I'll just say that these were not isolated stories. These were the stories we commonly heard across all the services. We really need to pay much more attention to the power imbalances that exist at the intersection of families and children and organisations and the Child Protection Authority. So we asked, how is it the system itself further entrenches marginalisation and stigmatisation, and what could make up the criteria for a more just child protection system? We developed what we saw as 4 pillars of institutional justice capital. Parental rights. Parents need access to effective legal advocacy and representation in courts. Just like the criminal courts, parents should have a right to the presumption of innocence and to have access to the resources that they need, including legal advice and representation, to understand and to challenge decisions that are being made about their children's futures right across the life of a child protection intervention. Public debate. We need public debate to have open conversations about what constitutes risks to children. Given that most of our children are removed due to subjective perceptions of neglect, we really need to debate what it means to be a risky parent. We need to be talking about this in terms of our families. What does parenting look like in an Aboriginal Torres Strait Islander family? We need to question whether having a disability or having a mental health issue or using drugs and alcohol necessarily presents risks to children. There can be a lot of safety found in families, networks of our children, and we know that these are not sought in a child protection intervention. Third pillar, respectful relationships. We need to actively support communities and community organisations to support families. Elders and Aboriginal and Torres Strait Islander community leaders and community organisations working with families have far more knowledge about the families and the resources that allow for supporting the safety of children. We need to provide forums that much better utilise this knowledge and respectfully support these relationships. We need to consider the justice capital needs of individuals, provide plain language resources, check in to see if interpreters are required, be prepared to have to explain things that are generally taken for granted that people know or understand. The fourth pillar is non-violence. We need to combat violence acted by the state. Families involved with the child protection system are some of the most marginalised and powerless members of our community. For Aboriginal Torres Strait Islander families, we need to actively guard against further harm, further adding to the harm that's already been incurred by our families' system. Intergenerational removals are a shocking reality for our families, and the transfer of trauma across multiple generations experienced by our families is largely unaccounted for or considered in policy or practice development. We need significant reform. In the process of thinking differently and moving to different ways of working in this space, questions will be asked. What if we get it wrong? What if a child dies? Or what if it gets injured? I've been asked these questions. I've done these presentations, and I have felt that I have had to defend myself. Despite public perceptions that our people would rather see a child in their community, even if something happens to them, we don't condone harm to children. We love our children. We would never agree to a child being left in a situation where evidence suggests there is a risk of abuse or harm to a child. Well, we know you don't need reform for things to happen to children. We've seen this many, many times. A child known to a child protection agency falls through the cracks. Something happens to them, they die, the media grab it, child protection authorities then withdraw and they become defensive. Inquiry is ordered and recommendations are made, and we tinker all about the edges, and then it's just returned to business as usual. The risk to children is not diffused when they're placed in care. Terrible things happen to children in foster care and in state institutions, and we know this. We know the long-term outcomes for many of kids who grow up in this system is poor. Alternative is doing nothing and continuing as we are. No, we can't do that. We can't continue to support a system that perpetuates systemic disadvantage of our people, a systemic disadvantage which serves both to remove children who may well be safe with their families and to miss cases of children who aren't safe. That's the reality. The stories of the kids at Banksia, the stories of the community workers, they tell it how it is. There's a disconnect between the policies and the operations of child protection work and how this plays out on the ground. By its very nature, it's highly relational work. In my role here at Telethon Kids Institute, I'm very privileged and honoured to work with the Ngunnawal Court elder co-researchers who provide their knowledge and wisdom and expertise to oversee and guide our research in the community. The elders with the Perth Aboriginal community identified 3 priority areas for attention: early childhood education and care, housing, homelessness, and child protection, child removal. As part of the project, the elder co-researchers developed child protection principles and practice recommendations. Elders here in Perth have called for a recognition of the harm that's been caused by the stolen generation policies, and they want this used as a foundation for formulating future policies and practices. They've highlighted the distrust of the welfare that continues to flow through our communities, and they call for child protection services to harness resources and connections from the vast social networks that exist in our communities. Call for child protection agencies and their workers to communicate respectfully with the community members in order to restore trust and build community relationships. Find community-led local solutions to child protection concerns. Provide a greater commitment to using Aboriginal family-led decision-making forums that prioritise our voices. Call for greater transparency and information for families about mandatory reporting. Who are mandatory reporters? What does mandatory reporting mean? By having this information means that there are families who don't access services for fear of being reported, children who don't attend school, children who don't have health checks. Historical trauma and distrust runs very, very deep in our community. Elders are concerned about the disregard of the Aboriginal and Torres Strait Islander child placement principle. We're currently working on a research project led by the elders and staffed by Aboriginal professionals and researchers We are exploring the benefits of providing support to individualise and foster cultural plans for Aboriginal children in the care of non-Aboriginal carers in 3 mainstream foster care agencies here in WA. This is critically important work. It's about a group of Aboriginal kids who've been removed from their parents and their families. Again, some of these kids are thousands of kilometres away from their country. This is an opportunity that they may not otherwise get to know about and to be connected to their kinship networks, to know about their country and their culture, their stories, to have the opportunity for cultural experiences, to know about their language and to spend time with elders. There are so many potential intergenerational benefits. Our grandmothers, our nans, are the social and community glue that keep our families together. And we saw that in the documentary that you've just watched, the work of Grandmothers Against Removals, the work of the Ngunnawal court elders here, my elders on Ngunnawal country. In all our communities, the work of our nans is tireless and frankly, way more difficult than it should be or needs to be. In the Banksia research, I yarned with many nans who were looking after their grandchildren. Some of these nans were looking after up to 15 grannies, very often without support and again with a really deep distrust of the welfare. Our communities, all our sisters are aunties, all our nans are mums, all our brothers are uncles, our pops are dads, our kids are cousins. We need a much greater understanding among non-Aboriginal people about cultural differences in what it means to be part of an Aboriginal kinship network and what this can provide to bolster the safety of children to live with their families and their communities and embedded in their language and their culture. We must recognise the incredible work undertaken by our grandmothers to keep their families together, and we must acknowledge in this process that nans are largely unrecognised and supported. There are significant economic savings in child protection expenses for these children that is not reinvested in support or back into the community, and this should be one of our biggest investments. And many Aboriginal leaders in research, in the arts, in sports and community services right across the board, strong leaders, and many of our younger generation are emerging as skilled agents for change. It's our responsibility now to set the table for our future generations. We need a commitment from governments around Australia to invest in and resource and support our elders, our emerging young leaders and our Aboriginal community-controlled organisations to lead reform and decision-making about the safety and wellbeing of Aboriginal and Torres Strait Islander children. For me, that's why the Australian government said sorry. The apology was an incredibly powerful moment for me personally. It was my hope that by saying sorry, we had an opportunity to redress the harms and revisit the way child protection work is done with our families. When a family, particularly an Aboriginal family, comes under the scrutiny of the state for child welfare concerns, we need an entirely different approach. What we've done in our work with the elders is to combine our 2 knowledge systems together. So we've got the cultural wisdom and the knowledge of the elders in the community with academic knowledge of regulatory theory. We can understand what the elders in the community call for by thinking about the principles of responsive regulation and the use of regulatory pyramids. You know, that is, consider holistically the cultures and the behaviours and the environments of our families. Regulatory pyramid models use soft sanctions to offer advisory and persuasive measures for dealing with the problem first. What Professor John Braithwaite there at RegNet describes as using carrots before sticks. The greatest focus of regulatory pyramid models is eliciting cooperation and self-regulation. And where these soft regulatory responses fail, regulators progress up the pyramid to enforce results and then should move back down the pyramid as compliance is achieved. So a regulatory pyramid holds the community centre at the centre. You don't reach straight for the top of the pyramid and get a court order. That's what happens now. Take first, ask questions later. And then remember, the Family Matters report tells us that over 84% of these kids, their accusations are unsubstantiated and our kids suffer all kinds of harms. Sorry meant anything, asking questions about historical involvement of the state and hearing these stories of our families should invite a fundamentally different response to the family. A unique individual response led by our elders, led by our Aboriginal community organisations and the community to redress the harms that a family could have suffered over many generations. Responses where the focus is on recovery, on providing recovery pathways and on ensuring everything is provided to safely care for their children with their families and their communities and on their country. Thank you.
Sharynne, we did have some questions planned. Are you okay to keep going with those if I ask you those?
Yes.
Wonderful. So just got two questions for Sharynne. Can you give an example of the types of things that can build positive personal or institutional justice capital?
Yeah, so forums like this, where, you know, where spaces that are open for us, up for us to come together and have these conversations and to talk about our visions and ideas and ways of working together in the future. And on that, I'd really like to thank Saskia and Sarah and the team there at ANU for all the work that they've done to bring this and facilitate this event. Thank you, is really important. Voice to Parliament, great example of institutional justice capital, a place where respectful relationships can be built and where we can have a voice in public debate that can potentially influence, you know, the policies and the practices that regulate our lives. Aboriginal family-led decision-making forums, you know, this work actually being done in WA to pilot the effectiveness of these forums. So we'll be watching that space. Truth telling about our history and its impact in our schools and in university curriculums. Very few dedicated advocacy and support services for parents and family members involved with child protection systems around Australia, and yet that's critical. I can't tell you how many times we've written affidavit responses for parents who've had their children removed because of what's called here a Friday afternoon special. So parents go to the school on a Friday afternoon to pick up their kids and they've been taken by child protection. They're given court papers, and I have to say they're often fabricated, or half the facts, and they have to go to court on Monday. How are they going to get effective legal advice over the weekend to challenge us? These are the things that we need to step into this space and do, and we shouldn't have to. We should have services that provide this, regardless of, you know, what's happened. People have rights. You know, we can really think about investment in dedicated services as a positive justice capital asset. It's a way of providing families with the resources and explanations and, you know, what the department require, tips, you know, strategies, things about personal empowerment, peer support, mentoring, legal advice, a way of providing services and authorities with the information they need to make informed decisions about safety of children. I think, you know, we can also think of it as a positive institutional capital asset as well. It fulfills that first pillar, the parental rights, and the third pillar, respectful relationships, you know, providing forums that create an environment for respectful relationships and between, you know, families and workers. And, you know, that's just good for everyone. And charters, they're a personal justice asset. Across most sectors, there are charters, there are customer charters, there are rights charters that should play a significant role in guiding relationships, in expectations and for procedural fairness. In our research in Canberra, we consistently heard stories from community organisations that there was no such thing as rights or procedural fairness for families involved with the child protection system. So we worked with the community there on Ngunnawal country to develop guiding principles for parental and family rights for the Australian child protection system. And through the advocacy of the Family Inclusion Network here in WA, and the government picked this work up, and they've become the first state to commission the co-design and formal implementation of a charter. The ACT government are also in the advanced stages of completing a community consultation and developing a charter, and we're looking forward to watching the progress of this in the coming months. That's probably off the top of my head.
And that leads to my second question. Have you had feedback on the effectiveness of the WA Charter of Rights for Parents and Family Members?
So it would be really interesting to evaluate this. I'd like to know more about the accessibility of the charter. You know, is it being routinely provided to parents when they come into contact with the system? Do the community organisations know of and have access to it and encourage family members to advocate their rights using the charter statements? I've had some conversations with parents about whether they think the charter's useful. For some, there hasn't been a lot of change. For a few, there's been change where previously there wasn't much hope. And I have to, you know, they all felt that it was something they can tangibly hold on to and be empowered to say, but I have a right to that information. I have a right to participate and be involved when you're making this decision about my children. And that can only be a good thing, right? You know, definitely a positive personal justice capital asset, definitely.
Thank you so much, Sharynne. Can we please just give you another round? It's been so incredible to hear about your amazing expertise on recovering justice capital. And thank you for also sharing your personal experience with the child protection system as well. I think we've all learned so much that, Sharynne, you can't see the audience, but there have been people with notepads writing notes and taking photos of your slides. But before you go, there's a piece of paper Sharynne's provided, further resources, readings for you to take. And there's lots of amazing stuff to read. And we've also got Sharynne's slides if you would like them. But yeah, just want to say such a massive thank you. We appreciate it so much. You're so kind to your time. So yeah, thank you. Yeah.
Thank you very much. Yeah.
If you would like to join the project, please use the QR code and speak to us. I would love to speak to you, but I know this has been a massive thing long of it. So we can go, but thank you so much for coming. Really appreciate it.